now in session. The Honorable Scott Makar, Judge, presiding. All persons have business before this court drawn here. Give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good morning, everyone, and welcome to the 5th District Court of Appeal on a great Chamber of Commerce weather day for the community. We have two cases on our docket, and we have allocated 15 minutes per side in each. So for each of the appellants who come up, please let us know how much time you want on rebuttal, or if you're a cross appellee, how much time you want on reply. So with that, the first case we have this morning is 22-273. Hopefully I've got this right, Melchior versus Voetzel. Is that correct?
Your Honor, I think it's Melchior.
Oh, okay, well, very good.
But it's close enough. May it please the court?
Have you reserved rebuttal time?
Yes, Your Honor, I would like to reserve 3 minutes.
Okay, great. Please proceed.
May it please the court, my name is Ezekiel Lugo, and I represent the appellants David and Marcella Melchior. This morning, we request that the court reverse and remand for two main reasons. First, that the exclusion of Dr. Goldberger's opinion regarding consumption of alcohol by the driver decedent was error. And second, that the multiple improper comments by plaintiff's counsel deprived the defendants of a fair trial. And my presentation this morning will focus on Dr. Goldberger's opinion unless the court wants to address the improper comments in detail. So turning to that issue, the trial court erred by excluding Dr. Goldberger's opinion for two main reasons. The first reason is a procedural reason that the motion that the plaintiffs filed was facially insufficient. The case law in Florida that's developed about Daubert motions to exclude expert testimony, and that's the main one that we're relying on is the Booker case out of the first DCA. And Judge Makar, you were in that panel. That case said that the motion has to be timely, and it also has to be facially sufficient. There's no timeliness issue here. The problem is that the motion was not facially sufficient because it was not supported by any contrary scientific literature or expert opinion that established that there was a problem with Dr. Goldberger's methodology in this case. And that's different from another case that where this court reviewed Dr. Goldberger's opinions. That case is Vitiello versus State at 281 Southern 3rd, 554. In that case, the criminal defendant filed a Daubert motion challenging Dr. Goldberger's opinion that was supported by testimony from another forensic toxicologist from the Hillsborough County Medical Examiner's Office. And that contrary expert said the evidence, the facts that are before Dr. Goldberger are not sufficient for him to render the sort of opinion that he did in that case.
Well, if I could interrupt just a moment. Yeah. The standard of review that we're charged with applying here to the trial judge's ruling is what?
The ordinary standard of review that applies to the exclusion of testimony is abuse of discretion. But of course, that discretion is limited by the correct application of the statutes and the case law. So in this case, we have an issue about the proper application of 9702 and the case law that applies to Daubert motions in general. And that's based on Florida law.
Because it seems to me it's a pretty close call in terms of this issue. So what kind of puts it more into your camp? So that's an abuse of discretion or a reversible error?
Well, the first reason is that the plaintiff's motion was facially insufficient. They didn't submit any contrary information. They relied on Dr. Goldberger's deposition. And in that deposition, Dr. Goldberger went through the facts, the factual information he relied upon, and he never said, I don't have sufficient facts or I'm missing something. The challenge went and focused on the data related to the blood draw that Dr. Goldberger used. that number of 13 milligrams per deciliter from the blood that was drawn when the driver decedent arrived at the ICU unit and the blood was checked for alcohol content. That's what the challenge went to. They were not challenging Dr. Goldberger's methodology. He took that number and he applied a conversion rate, and he came up ultimately with the opinion that there was alcohol in the driver decedent's blood, and that amount of alcohol correlated to one or two alcoholic beverages before the accident. He was asked about the conversion rate, and in a question that asked him if he used the range that's universally used for these sorts of calculations, and he said, yes, the experts at the FDLE use a range usually between 12 and 18%. Dr. Goldberger used 15.
Is there anything in the statutory text that says that a movement needs to say the things you're claiming on behalf of your client that the motion needs to entail? Is there anything in the text itself that says a motion shall include these elements?
No, Your Honor. So 9702 says that if the expert is qualified by experience, training, and so on, the opinion is admissible if, 1, it's based on sufficient facts or data, 2, it's reliable, and 3, will assist the trial fact.
And I know we have the confluence of the responsibilities of the Supreme Court of Florida versus the legislature, but there's no procedural rule by the Supreme Court of Florida saying that a Daubert motion needs to include the components you're talking about, correct?
Not in the statute and not in a published rule of procedure, but I believe the opinion where the Florida Supreme Court adopted Daubert or adopt to the extent that the statute has procedural aspects, the Supreme Court usually issues an opinion adopting that, and in the opinion where the Supreme Court did that, I believe it noted that it was pursuant to the case law, the federal case law that was already in place in this area, that was already pretty well developed by the time Florida switched from Frye to Daubert. The first DCA, when it issued that opinion, it relied on federal case law.
And you're talking about Booker. Booker
Correct.
Was a workers' compensation case?
Yes, Your Honor.
Isn't that a different paradigm? A whole different set of rules, whole different set of algorithms for this court to evaluate?
The issue in that case dealt with 9702 on a Daubert motion. And
Which I understand, but you would agree comp actions are different than personal injury actions, would you not?
They are, Your Honor. But the specific issue that was addressed in Booker, the first DCA didn't indicate that it was based on principles applicable solely to workers' compensation cases, unlike in other situations where the court goes out of its way to explain that in its opinions. But even if the court doesn't agree that the motion was facially insufficient, there is still a problem here because the plaintiff's sole challenge went to the methodology related to the underlying facts upon which Dr. Goldberger relied. There was no challenge to Dr. Goldberger's own methodology. And that's important because the case law, again, from this court, the Vitiello case, has made it clear that challenges to the underlying factual basis of the expert's opinion is a matter that goes to weight, not to admissibility.
I have a couple of questions, counsel. As to your second point on appeal, the closing argument issue. First, there was no motion for remittitor that was filed in this case, correct?
Correct, Your Honor.
And would you agree that the amount awarded, and I'm looking at the statute, was not indicative of prejudice, passion, or corruption on behalf of the jury, as far as the amount?
As far as the amount, that's correct, Your Honor.
And that there was no indication from this record that improper elements of damages were considered by this jury, correct?
Correct, Your Honor.
So is that not indicative, I know it's not dispositive, counsel, but is that not indicative that this jury was not affected in a prejudicial way to cause this jury to do something that it would not have otherwise have done?
Not in the context of the issue that was, the issue before the court, which is the granting of a new trial, not a remittitor. The argument is not that the amount awarded was excessive. Those factors will go to whether the amount awarded is excessive. The issue is whether the improper comments deprived the defendants of a fair trial, at least under the pre-special case law, special versus West Boca case from the Florida Supreme Court, that looks at issues dealing with improper comments by opposing counsel. But our position is, and at least it was laid out in the reply brief, that the burden to establish the harmfulness is on the beneficiary of the error, the party that was responsible for the improper comments. And under the special case, the standard is whether there is a reasonable possibility that the issue, in this case, the improper comments, affected the trier of fact, the jury in this case.
So, but you would concede, counsel, and I know there's a liability aspect to this, but you would concede that those comments did not affect the damages determination, correct?
Well, Your Honor, it affected the damages consideration to the extent that the jury completely rejected the number that was proposed by the defense attorney. Remember, he suggested a range between $200,000 and $400,000 total, and the jury completely rejected that and went with a number that was above that range.
Well, what did the plaintiff's attorney ask for?
I believe they asked for an amount that was in excess of $1 or $2 million, Your Honor.
So they actually awarded less than what the plaintiff's attorney asked them to award, correct?
Correct, Your Honor. But the fact that they didn't award the amount that was suggested by the defense, and the fact that they answered no to question 2 dealing with the fault and never got to apportion any fault, shows that there was some harm, there was some effect on the jury by these comments.
Well, I think Judge Jay, unless I'm misunderstanding, may be suggesting that the improper comments went to the detriment of the client.
The client, the plaintiff.
Correct.
Perhaps, Your Honor, but perhaps it went to the detriment of both parties.
Right, that's why I'm just throwing that out for
But
consideration.
under Special versus West Boca, all that has to be shown is that the comments had there's a reasonable possibility that the comments affected the trier of fact, and there is some evidence that it affected the trier of fact as to the defense.
So we're not doing a harmless error analysis here is what I'm hearing. We're doing this.
Well, the harmless error analysis, Your Honor, is the analysis from the special case from the Florida Supreme Court that's based on the statutory language, which talks about not just evidentiary issues, but also misdirection of the jury, which we posit includes improper comments during trial. So yes, there should be a harmless error analysis as to that part too. But turning back to Dr. Goldberger, in this case, like in the Vitiello case, where this court analyzed whether there was a sufficient factual basis for Dr. Goldberger's opinion, in that case, this court explained that the challenges to the assumptions that Dr. Goldberger was using in his calculation of blood alcohol context in that case went to the weight and not the admissibility of the opinion. That's consistent with federal case law.
But counsel, just on the Vitiello case, didn't that case also state that that it would come in whereas here the expert testifies they've considered additional facts such as performance on field sobriety tests? That was a boating under the influence case, I believe. So I agree the holding doesn't indicate that you have to have these additional facts per se, but whereas here, as to Judge Makar's point, I think this is a close one. You know, you've got Dr. Goldberger testifying or at deposition saying, you know, that this could be within the margin of error, or if they used an alcohol swab, this may be a false positive. And there's no other evidence in the record, is there?
No, Your
alcohol?
Honor. No, Your Honor. And that question sounds like the court is concerned about the issue that rose in the State versus Barber case that was decided by the second DCA this year. And in that case, the second DCA said the extra evidence confirming that there was other indicia of intoxication was not relevant to the Daubert inquiry, and to the extent that the trial judge relied on that, The second DCA said the trial judge applied a Daubert plus standard, and that was a departure from the essential requirements of the law, and it required or it supported granting certiorari relief to the state in that case. In this case, Dr. Goldberger relied on those test results that are ordinarily admissible under Florida law. Florida law is clear that when evidence of blood alcohol level from medical records is being submitted, evidence about the methods, the timing, the chain of custody related to the underlying blood draw is not necessary. And that is because the fact that that's included in a medical record that used for treatment and diagnosis of the person provides sufficient indicia of reliability that makes it trustworthy.
Counselor, you're almost out of rebuttal time.
Oh, Your Honor, I didn't realize that included the rebuttal time, so I'll stop and I'll preserve my few seconds.
Well, we'll give you 2 minutes on rebuttal.
Well, thank you, I
Okay, we'll add
appreciate it.
a minute and a half to Applee's time, if that's possible, Mr. Marshall.
Good morning. May it please the court, John Bogdanoff for the Applees. I think the court noted at the outset that every issue in this case is subject to abuse of discretion standard of review. The issues relating to the blood draw and the alcohol issue, blood alcohol, are extremely significant in this case for 2 reasons. Number one, unlike any other case that's even the cases cited by the appellant, there was absolutely no evidence in this case of alcohol ingestion or consumption by the victim of the accident, other than this blood draw. Every case that the appellant cites involves indications of consumption of alcoholic beverages.
Why would that matter? I mean, obviously, it would help to support the idea that your client or the deceased had some beverages, but how else did the alcohol get
It's
there?
important in this case because of the extremely low reading of the blood alcohol. As Dr. Goldberger explained, the normal range is 0 to 9 milligrams per deciliter. This was 13 milligrams per deciliter. And Dr. Goldberger proceeded to explain that it could be the number above 9 could be accounted for if an artery was utilized to draw the site for the blood draw, as opposed to a vein, or if an alcohol swab had been used in connection with the blood draw. We don't know if either of those things happened because the appellant, as the party with the burden of presenting the evidence, didn't present any evidence as to how the circumstances surrounding the blood draw. So Dr. Goldberger acknowledged that, yeah, if they used an alcohol swab, that can account for a false positive. So in this case, the absence of any other evidence of alcohol consumption, as exists in the cases such as Barber, is critical because the number is so low. As Dr. Goldberger said, at most this might indicate, assuming this is not a false positive, that the decedent had 1 to 2 alcoholic beverages. But the number is extremely low. Dr. Goldberger also indicated, and this was another reason that...
Well, 1 to 2 beverages at what point in time?
Well, he didn't say.
Because if it was 1 to 2 beverages just before the accident, that's pretty significant. If it was 1 to 2 beverages 6 or 7 hours before, that's a different story.
And we have no evidence of that because the appellant didn't present any evidence.
I should probably know the answer to this question, but I don't. I apologize. But was there analysis by the expert saying, okay, let's assume we admit this report, there's this low percentage of alcohol in the driver's blood system. Given the facts of the accident, would that level of potential impairment have caused any difference in the outcome of the accident? Because if I recall correctly, one of the vehicles the one that hit the deceased was traveling 30 plus miles an hour over the speed limit.
Correct.
And the deceased were just making a turn onto the roadway. There was no light there, correct?
Correct.
Okay.
And they had come to a full stop, according to the only person who was present at the scene. She didn't actually see the collision, Mrs. Osteen, but she did see the Betzel's vehicle, and it came to a complete stop. She's the witness who testified that when that black pickup truck that the defendant was driving came by, she was shocked at how fast it was going, and she had seen the Betzel's car stop before it made the turn. The human factors expert, Dr. Kennedy, said that there was no way that Mr. Betzel could have seen the defendant's pickup truck because it was coming over a hill at such a high rate of speed, and the intersection was at the base, just after the base of the hill. So that the fact that he was going 70 miles an hour in a 40 mile an hour zone, Mr. Betzel would not have been able to see that. Once he committed to making the turn, it was too late. There was nothing he could have done. The other expert in the case indicated that had the vehicle been traveling at less than 70 miles per hour, such as 55 or even 40, the speed limit, the collision wouldn't have occurred. So it was the speed that made it impossible for Mr. Betzel, once he committed to making the turn, to avoid the collision. The contention that the motion to exclude the evidence, motion in limine, was defective from a technical standpoint. First of all, that was not raised in the memorandum that the defendants filed. They did raise that argument at the hearing before Judge Falvey, but Judge Falvey didn't accept that argument for several reasons, one of which was the specific challenges that the plaintiffs raised to Dr. Goldberger's testimony asserted a lack of adequate facts, lack of reliability, and confusion to the jury from an introduction of this evidence. The lack of adequate facts related to the lack of any additional information other than the fact that this was a 0.13 milligrams per deciliter, but we don't know if an alcohol swab was used, we don't know if an artery was the site of the blood draw, and Dr. Goldberger acknowledged that either of those two things would have possibly or reasonably could have been the result of why it was above the normal range. So there were inadequate facts. Section 90.702, which incorporates the Daubert standard, says one of the grounds for challenging an expert's testimony is lack of sufficient facts or data. That's exactly what we had in this case, a lack of sufficient facts or data. Judge Falvey found there was a lack of sufficient facts or data.
What about the second issue on appeal, the argument issue, the voir dire closing argument, the questions about the 911 call? What would you have us to do with that?
Well, first of all, the defendants made motions for mistrial just about every time,
So it's
something
preserved.
occurred. Well, not really, because they didn't object. What they did is they would say, motion for mistrial. We were deprived of
Hold on. You're saying that's not preserved when they asked the court for a mistrial? Why else would you ask for a mistrial if you're not objecting to the comment?
Well, the way it traditionally works is objection, Your Honor. The court makes a ruling. Yes, that was improper. Curative instruction, perhaps. We determine what short of a mistrial.
That happened too. You'd agree with that?
Only once. All the other times they immediately said, motion for mistrial deprived of a fair trial. And Judge Falvey said, no, this does not rise to the level of mistrial. I deny your motion.
What about, I mean, but the cases are seriatim. I mean, they're everywhere, saying that if you continually lose these objections, one, may not be a reason to stand up and interrupt anymore, but two, you may go ahead and cut to the chase. I mean, isn't that what this attorney was doing, just cutting to the chase of the mistrial motion?
Well, that's suggesting that there was nothing short of a mistrial that could have cured or addressed these issues. First of all, we don't think they were reversed, the error was committed. The references to two references.
Wait. None of these statements are objectionable in your view, counsel?
I think the references to community.
None of them were objectionable?
They may have been objectionable, but
these are trial practices that lawyers should follow?
I think they could have, any one of them that may have been an error could have been cured by a curative instruction. I don't think any of them deprived the plaintiff, the
That's not
defendant
my
of
question.
a fair trial.
That wasn't my question.
I'm
And
sorry.
yes, things can be cured by curative instructions, but my question is, are you telling this court today that none of these comments by this lawyer were objectionable in the least?
If they were objectionable, I think they could be cured by a curative instruction. I don't think any one of them deprived the defendant of a fair trial. And
Well,
that's the standard.
that's a different question.
Right.
There's
And-
multiple statements here. And I haven't seen a case like this where it seems like at every stage of the proceeding, this lawyer was getting up and making improper comments.
Well, I don't, first, a number of the comments that they allege were improper, such as a reference to the question of the defendant, did you stop to render aid? That question had been asked of a previous witness, Mr. Osteen was asked, did the defendant stop and render aid after the accident? No, he didn't. So then when the defendant is asked that question after that, after no objection had been made to the previous witness's testimony, they jump up and say, oh, objection, I'm sorry, mistrial. They're bringing out information about something that's not alleged. It was harmless because it had already been testified to without objection. How can it be prejudicial when that evidence was admitted without objection?
Well, Mr. Osteen was not asked about the 911 call, was he?
No, but his wife did testify that she heard the defendant on the telephone telling somebody, I'm going to be late, I'm not going to be able to make it, I've just had an accident. So there's no indication, I mean, there was evidence that he was not on the phone making a 911 call. So all this contention that somehow this, we were horribly prejudiced, it's not supported at all by the record.
Well, you would agree that was not germane to this action. There was no pleading saying there was a failure to render assistance, there was a failure to call 911, and that's another feature of our claim against the defendant in this case.
Yeah, there was no claim. And in fact, when that question was asked of the defendant, counsel for the plaintiff said, I'll withdraw the question. And the judge said, okay, let's move ahead. There was no prejudice to the defendant under the circumstances of that situation. They also moved for a mistrial, claiming there was no evidence of life expectancies in order to establish damages for the survivors. They've withdrawn that one in their reply brief because there was evidence of life expectancy. The two sons testified at trial, and this court in the McQueen versus Gersani case said that's enough for a jury to make a determination. By seeing these witnesses, they can make a determination as to appropriate damages in the case. So they've withdrawn that one. So they just kept raising all these motions for mistrial, many of which were completely bogus.
Back to Judge Makar's point, you aren't commending the disparagement defense counsel saying there was a failure to follow the law, are you? You're not saying that's good trial practice? No,
that's not. And when you do read the closing argument of both sides, you hear the defense counsel saying, it's just like a used car salesman when he's referring to the plaintiff's case. I mean, there was back and forth on both sides.
What about the statements during jury selection? That a civil jury is speaking for the community, speaking with one voice. Are you condoning those statements?
I think that using that phraseology was improper. Saying that the jury, is here, to follow the law and the facts would have been the appropriate way of doing it. But again, motion for mistrial, Your Honor. And this is right out, we're just starting the case. There was no plea us against them. There was no punish the defendant. Do something to the defendant. It was probably a poor choice of words, but the defendant says, motion for mistrial. And Judge Falvey says, no, I'm not going to grant a mistrial.
You seem to be hung up on this motion for mistrial. I don't get it. I mean, to me, that's an objection. And I don't understand why you keep harping on that. They brought it up time and again when the improper comment was made, motion for new trial. I mean, if they said objection, motion for new trial, is it any different?
Because you're not giving the judge the option of a curative instruction. You're telling the judge, I'm rolling the dice. This is, this
Well, why does the
requires.
judge have to why can't the judge decide what to do with the motion? And I'm going to give a curative instruction.
Well, I don't know that it's the burden of the judge to do the work of counsel. The judge says.
The judge runs the courtroom.
But the judge says, you've moved for a mistrial. I know what the standard for a mistrial is, that it's vitiated the fairness of the trial. And I don't see, I'm sitting here, I'm looking at the jury, I don't see where this is comment. It may be inappropriate, but you haven't told me, object, Your Honor, and then we can talk about it, and maybe we'll do a curative instruction. Maybe further argument will reveal that, a mistrial is appropriate, but judge, motion for mistrial, in fact, that's exactly what it says. Motion for mistrial, fairness of the trial has been, effectively destroyed. And this is an opening, and the judge says, no. I don't think, yes, it preserves it, but it doesn't follow the traditional way of handling these things. It's telling the judge, I want a mistrial. This thing is over, case over. And the judge is saying, no, I don't agree with you. I don't think this rises to the level of a mistrial. It may be objectionable, but it doesn't rise to the level. So I'm going to deny your motion for a mistrial. I think Judge Falvey had every basis for doing that. And to say it's an abuse of discretion, I think is totally unfair. Just like I think in this case, the jury considered the evidence. The jury considered the evidence of liability, which was overwhelming. The jury considered the evidence of damages. And I think in this case, the jury did a pretty good job. They came back with a verdict that, was probably not satisfactory to the plaintiff. And to be honest with you, plaintiff had asked for, much more. Was probably not satisfactory to the defense. The defense had asked for somewhat less, although the verdict was much closer to what the defense had asked for than what the plaintiff did. But I think in the end, this jury did a really good job. I think they weighed the evidence. They ignored anything else that, might have been going on. And I think in the end, they came up and they did a very credible job. And to say that we should set aside what they did on some, very uncertain and unclear, argument, I think is not fair to these folks who've participated as jurors in this case. I don't think there was any abuse of discretion has been established. I think the mistrials, the judge was within her discretion in saying that I don't see that this trial, the fairness of this case has been compromised. And I think the verdict of the jury at the end substantiates the judge's decisions that she made. I think, if anything, it shows that the judge was correct, that this was a fair trial. Any questions?
Thank you, counsel.
Okay, thank you.
May it please the court, I would like to address both of the issues on appeal. I have not seen a case with as many improper comments in the same case, and they extended from jury selection all the way to rebuttal. Our position is that there's clearly harm to the defendant, both as to liability and damages. I understand the court is concerned that there was no harm potentially as to damages. If so, that would affect or should affect the scope of the remand and not the decision to reverse. If the court doesn't think there was harm as to the damages, then the remand should be limited to a new trial on the issue of the driver decedent's liability and any apportionment of fault. These comments were preserved, and a lot of these comments are indefensible. On the liability part, on Dr. Goldberger's, the argument as to Dr. Goldberger, I would like to correct something I heard from opposing counsel, that the record was undisputed that the driver decedent stopped before he made the left-hand turn. That is not correct. The driver and the driver's passenger both said that this car just invaded their lane and did not stop. The plaintiff's accident or human factors expert said that there was no evidence that the car came to a stop. The plaintiff's accident reconstructionist said that if they had stopped and waited 2 seconds, the accident would not have happened. So in this case, Dr. Goldberger, part of his opinion, part of what he was going to say is that even having one alcoholic beverage can have an effect on perception, and he said that on page 565 of the record, and it can affect behavior like judgment or decision-making on page 566. That's relevant because that would have explained why the driver decedent decided not to stop at that particular intersection, which his son testified was a dangerous intersection, and his son testified he has spoken to his parents about the danger of this intersection. Together, both the comments and the issue with Dr. Goldberger support reversing and remanding, at least for a new trial on the liability issues.
Thank you, counsel.
Thank you.